Probates are really scary. They're expensive, they're public, they cause delays, and they're super stressful. But did you know that there is a baby probate or a mini probate? Or, all right, I made all those terms up. The more common term is called the small estate probate. When you hear small estate, the first question is, how small? Small estate limits are actually quite small. Here are a few examples. This is just the first few states in alphabetical order. You can see that the limits are mostly between $25,000 to $50,000, and the states I highlighted in blue have a higher limit, $100,000 or more, but you can see they're not even half the list. If you want to see what the small estate limit is of your state, you can simply Google it. You might think, that's really small. This doesn't apply to me. But wait, because the way you calculate the small estate is interesting. A lot of things are excluded from the calculation. Okay, let's see what they are. First, any property that has joint ownership is excluded from the calculation of the small estate because upon death, these assets simply goes to the joint owner. It will not be probatable. Anything that you have protected inside your living trust is also excluded because those assets are not probatable. If you have specified designated beneficiaries, they're also excluded. If you have a 401k that you forgot to specify a beneficiary, then it will be included. Bank accounts and brokerage accounts that have transfer on death or payable on death designations will also be excluded from the small estate calculation. And some states are even quite generous by allowing additional items to be excluded. For example, in California, houses that are under $750,000 will be excluded from the small estate calculation. Of course, if your house is inside a living trust, it could be $5 million and that will be excluded from the small estate. So it's possible to have a really big estate, but they're all protected inside your living trust or have been designated beneficiaries. So your small estate is actually quite small. As you may expect, there are rules on who can file for a small estate. It's not just the threshold limit. Let's go through them, okay? Every state has different rules, but here are the 5 things that you want to be looking at. What is the small estate limit? We talked about that. What is excluded from the calculation? Example, in Massachusetts, 1 car is excluded from the calculation. In Florida, you could have a $5 million home and that will not be included in your small estate calculation. Another consideration you want to look at is, what are the disqualifiers? For example, in Massachusetts, your small estate could be under the limit, but if you have any real estate, no matter how small it is, if you have any real estate that is not under the protection of a trust, so basically you have real estate that is going into probate, then you cannot use the small estate. In Florida, you have to prove that all debts have been paid, funeral expenses have been resolved before you can file for the small estate. So you want to check what the disqualifiers are for your specific state. What's the waiting period? Some states impose a 30-day waiting period, some 40 days. And the idea is that it gives you time to make sure that the small estate calculation total is under the limit. And before you file, you want to make sure that you have all the documents ready. They're typically the death certificate, proof of ownership of the asset, and your ID. So who can benefit from the small estate probate? If you have bank accounts that you forgot to designate beneficiaries, that is one example that the small estate proceeding could be helpful to claim those bank accounts. Another example is you go through your parents' home and you find recent undeposited checks. Well, you can't deposit the checks into your account because it's not under your name. And you can't deposit it into your parents' account because the bank account has already been distributed to the beneficiaries, for example. You can list this undeposited check in your small estate proceeding filing. It's also often used to transfer titles of cars upon death. That's my situation, actually. In Massachusetts, we do not have transfer on death deeds on motor vehicles. And I'm reluctant to put a joint owner on my car. So upon my death, my children will have to use the small estate provision to transfer the title of my car into their names. Personal items like golf clubs, an expensive violin, not a Stradivarius, that would just exceed the limit, but personal items that you forgot to put in your personal item memorandum. And finally, some states allow you to transfer homes if it's under a certain value to your heirs through the small estate affidavit. It's important that I go through this last slide with you. The small estate proceeding is not for everybody, okay? What are the situations where it could hurt you more than help you? One, if your heirs don't get along. For one, they won't sign the small estate application. You need all the heirs to sign that, and they just won't cooperate. Or you know that there's some disgruntled heirs who will dispute the outcome in the future, then you really want to go to a full probate to have a judge determine the outcome and put a lot of teeth in the outcome so it's not disputable later. Another reason that you want a full probate is because you suspect that there are creditors out there that you need to identify. In a small estate proceeding, it's your job to identify the creditors and to notify them about the person's death. In a full probate, it's their job, it's the creditor's job to come forward and make claim on the assets. It is their legal opportunity to speak up. And if they don't, they lose that opportunity. It's not on us. Another reason you might want a full probate is because you think there may be a potential estate takeover. What on earth is that? I bet you thought only the Rockefellers and the estate of Elvis Presley get this much excitement. So potential estate takeover is if you believe there may be an heir out there who has plans to swoop in and take over the executorship and file a full probate on the estate. Because the minute a full probate is filed on the estate, then you can no longer file a small estate probate. Do you need the powers of the executor to take certain action, to evict someone from their home or to force a sale of an asset? An executor has powers that allow them to do that, but in a small estate proceeding, it's just a filing, and the filer is the default executor. It doesn't have as much teeth and power as the executor in a full probate. Or you may have special circumstances that requires a court order. Example, your parent has a bank safety deposit box, and the bank simply has a policy that they need a court order to release the deposit box. In that case, you'll have to go through a full probate. The small estate probate proceeding could be very helpful, could be a lifesaver, but think of it more like a AAA membership. It's really handy when you lock yourself out, when you ran out of gas, or when your battery dies in the middle of the highway. But it is not an estate plan. You still need a good car to get around, to not cause big problems in your life. And that solid good car is your Revocable Living Trust. If you are new to Revocable Living Trust, watch this video here. You'll see how for most people, it is a very effective way to shelter your assets from probate. But more than sheltering your assets, it's really about sheltering your loved ones from the hassle of probate.